Memorial Day weekend just hit. School is officially ending.
And right on cue, just like every year without fail, my phone starts lighting up with calls from parents who are absolutely losing their minds about summer.
She signed the kids up for a summer camp in Asheville without telling me. He's planning a trip to Disney that overlaps with my vacation week. My order says reasonable summer visitation, and I have absolutely no idea what that means. Can I leave my 12-year-old home alone while I work? She keeps calling it babysitting when he has the kids for the summer.
I am telling you, summer is the single busiest season for family law attorneys in North Carolina.
And most of the calls we get are about situations that were completely preventable.
Hi, my name is Connor Green.
My name is Allie Moore. I'm an attorney at Cape Fear Family Law in Wilmington, North Carolina.
And this video is your summer survival guide. Everything you need to know about summer visitation, exchanges, summer camps, leaving kids alone, and how not to end up in front of a judge in July.
Which, trust me, is not where anyone wants to be in July.
The first question I get every single May.
When exactly does my summer schedule kick in? And the honest answer is, it depends on entirely what is in your order. And this is where a lot of parents get into trouble. Some custody orders say summer begins on the last day of school. But here's the thing. In North Carolina, that day is not the same across every county. New Hanover County schools, Brunswick County schools, Pender County schools, they all have different last days.
If your order just says last day of school, and you and your co-parent have kids in different school systems, or if one parent has already pulled the child for travel, that language matters. When your order was written, did anyone specify which school calendar? Because if it didn't, that ambiguity is a fight waiting to happen.
Other orders say summer begins on a specific date, June 1st, June 10th, whatever was negotiated. Some say within 48 hours of the last day of school. These are not the same thing. If your order says June 1st and the last day of school is June 12th, guess what? You don't get the summer schedule until June 12th, regardless of what your co-parent thinks. My strong recommendation, and I cannot stress this enough, is to read your custody order right now. Not in June, right now. Know the exact language about when summer visitation begins. If the language is ambiguous or unclear, now is the time to address that, either by agreement with the other parent or by going back to court before summer starts, not during it.
Let's talk about exchanges, because summer exchanges are different from your school year exchanges. And a lot of parents don't think about this until they're standing in a parking lot at 9 o'clock at night with a confused child and a co-parent who is furious about something.
During the school year, exchanges are usually tied to the school schedule. Child goes from mom's house to school, then dad picks up at school. Clean, neutral, automatic. In summer, that handoff structure disappears, and suddenly you have to actually coordinate. What good summer exchanges look like in practice: a neutral public location, like a McDonald's parking lot, a library, a police department, exchange zone if safety is a concern. Yes, some communities have safe exchange locations, and yes, you can use them. The goal is neutral ground. Not your house, not their house. Not a parking lot where someone is going to film the handoff and send it to their attorney, though that does happen.
Second, be on time. I know that sounds obvious, but in the world of family court, being consistently late to exchanges is a documented pattern that can be used against you in a modification hearing. Courts take parental respect for the other parent's time seriously. If you're regularly 15 minutes late, you are giving the other parent ammunition. Set a reminder, leave early. It matters.
Third, what comes with the child? Summer is not an excuse to send your child to the other parent's house with no clothes, no medications, no summer gear, no sunscreen. Your custody order may have provisions about what has to travel with the child. If it doesn't, co-parenting best practices say each household maintains some basics, and the primary school year bag travels back and forth. Medications especially. Please do not use medication transfer as a power move. That one hurts children, and courts notice.
Okay, summer camps. I want to dedicate real time to this because it is one of the top 3 reasons parents end up back in court in the summer, and is almost always avoidable.
Here's the scenario I see on a loop.
Parent A registers the child for a 4-week residential camp in the mountains without telling Parent B. Parent B finds out from the child. Parent B is livid because that 4-week camp overlaps with their summer vacation week.
Parent A says the camp was their decision because the child lives primarily with them. Parent B says this is a unilateral major decision that required joint input. And now both of them are in my office spending money they could have spent on a vacation.
So let's talk about the legal framework. In North Carolina, joint legal custody means both parents share the right and responsibility to make major decisions about the child's life, education, healthcare, and often extracurricular activities. Whether summer camp falls under joint legal custody depends on several factors: the specific language in your court order, the cost of the camp, whether it requires travel, and whether it impacts the other parent's custodial time. A week-long day camp at the local rec center, probably one parent's call. A 6-week residential camp in another state that swallows the other parent's entire summer vacation week, that's a joint decision.
The rule of thumb I give clients: if the camp significantly affects the other parent's parenting time, you need to give notice and get input before you register. Before, not after. Not, by the way, I signed them up. Before. The same way you'd want a heads up before the other parent books something that ate into your schedule. Now, who pays for summer camp? Also a fight. Also addressed in a lot of custody orders. Some orders specifically address summer camp costs as a part of child support or uncovered expenses. Others are silent.
If your order is silent, the general framework is that extraordinary expenses, which a residential sleepaway camp often is, are shared in proportion to income, and the parent who wants the camp is typically the one who initiates the discussion about cost sharing. If you enroll your child in a $1,200 camp and then bill the other parent for $600 without any prior agreement, that fight is coming.
Get the cost agreement in writing before registration. Here's a practical tip. Put the summer camp conversation in writing. A text or email is fine, at least 30 days before the camp registration deadline. Give the other parent an opportunity to weigh in on cost and scheduling. A documented conversation is your protection if it later becomes a dispute.
Let's talk about money, because summer is expensive and custody orders often don't fully address what happens when school is out of session and both parents are working. Work-related childcare costs during the summer, daycare, a summer camp used as childcare, a nanny, a summer program that covers working hours. These are generally treated as childcare expenses under North Carolina child support guidelines, meaning they factor into the child support calculation. If your child support order was established when childcare costs were different and summer dramatically increases those costs, that is a conversation worth having with your attorney.
Extracurricular activities are a different bucket. Swim team fees, travel baseball, gymnastics camp, theater intensives. These are activities, not childcare. And your order may or may not address who pays for that. Most orders either list specific activities that will be shared, or they say something like, each parent pays for activities during their parenting time. Some orders require consent from both parents before enrolling in a costly activity. Know which category you're in.
One more thing on money. Please don't use the question of who pays for summer camp as a bargaining chip for something else. I'll agree to camp if you give me extra time in July is a negotiation that sounds clever until it lands in front of a judge. Courts see through that, and they do not appreciate parents using their children's activities as leverage in a financial dispute. Keep the child's experience and the money conversation in their proper lanes.
Summer vacations. Nobody talks about this enough. Most custody orders have provisions about out-of-state or out-of-country travel with the child. Some require advance written notice. 30 days is common, sometimes 60. Some require providing an itinerary, flight information, and contact details. Some require the other parent's written consent for international travel. If your order has these provisions and you ignore them, you are creating a legal problem, even if the vacation is completely innocent and well-intentioned.
Passports are a specific issue I want to flag. If your child doesn't have a passport, both parents generally need to consent to the passport application. That's federal law, not just a custody rule. If you're planning an international trip this summer and your child needs a passport, start that conversation now. Not in May, now. Passport applications can take weeks, even with expedited processing, and if the other parent refuses to sign, that becomes an emergency motion, which is expensive and nobody wants that.
One more travel scenario I see constantly. A parent books a vacation that overlaps with the other parent's scheduled summer week. Sometimes this is an honest scheduling conflict. Sometimes it's tactical. Either way, the moment you book travel that affects your co-parent's time, communicate proactively, in writing, not a week before departure. The question, "Why didn't you tell me sooner?" is not a question you want to be answering in a contempt hearing.
All right, here's what I want you to walk away with. Summer custody conflicts don't have to happen. The vast majority of the emergency hearings and contempt filings I see in June and July were entirely predictable and preventable. So before Memorial Day weekend is over, here's your checklist. Look, co-parenting in the summer is hard. It's a long stretch of unstructured time. The kids are home, everybody's routines are disrupted, and emotions run high. I get it. What I want for you is to get through the summer without spending money on a family court filing that a conversation and a calendar could have prevented. You both love your kids. That's not in dispute. The question is whether you can communicate well enough to let the summer actually be good for them. If you need help reviewing your custody order, modifying language that isn't working, or working through a summer schedule dispute that's already brewing, reach out. Cape Fear Family Law handles custody matters throughout Wilmington, the Cape Fear region, and Durham. The link for a consultation is in the description below.
And if you found this helpful, share it. Because there is another co-parent out there right now who is about to make a very expensive phone call in June that this video could have prevented. Thanks for being here. Enjoy the summer.